By the end of this week, the UN Convention on the Law of the Sea, or UNCLOS, would have been in force for 30 years. A treaty that redefines nautical boundaries from what they once were. That was how far a cannonball could be fired from a shore, to a somewhat more precise measure. The treaty was adopted in 1982 and enforced from November 1994. It drew on earlier treaties and customary laws. An international wrangling over the overexploitation of resources, making clear the need for regulation to ensure the proper jurisdiction over and thus protection of marine reserves. In essence, UNCLOS sets a territorial sea limit for all countries at 12 nautical miles, and an exclusive economic zone, or an EEZ or EZ, of up to 200 miles, both from a so-called baseline. Beyond that is the high seas. The treaty also stipulates that an island is entitled to a territorial sea, an EEZ, and a continental shelf. But even with legal power overseeing international governance of oceans and seas, there are still disputes. And those that make the headlines are often caused by underlying political tensions, or in the worst cases, a fundamental rejection of the international rules-based order. Maritime boundary disputes are found on all continents, with more than 100 still unresolved. Notably between Israel and Lebanon in the Mediterranean Sea, Greece and Turkey in the Aegean Sea, and the Eastern Mediterranean, all the way to Asia, where clashes arise between claimant nations in the South China Sea. Here, efforts have been made to try and ease tensions. A code of conduct has been in the works between ASEAN and China to promote a peaceful and stable environment. Meanwhile, as countries bump heads at the negotiating tables, the potential remains for more confrontation in contested waters.